Good afternoon, ladies and gentlemen. Welcome to the Washington County Public Affairs Forum the day before the insanity stops. It's interesting, everybody knew what I was referring to. Anyway, ladies and gentlemen, we had a wonderful program today, and unfortunately it's going to have to be postponed. Early this morning, we got a call from our speaker from the Beaverton CERT program, and she's unfortunately ill. So watch the space on the website, and we'll see when she's able to come back. We wouldn't want to take advantage of the Beaverton City Councilor to explain that, because actually we were very lucky. Today we have a last-minute substitute, which is not going to cause us anything other than to be grateful. Ladies and gentlemen, John Tyner is a former president of this organization and a current board member, and he was kind enough to step in. Today he'll be discussing some of the recent state Supreme Court rulings. And we're not going to talk about the election anymore at all. Ladies and gentlemen, without any more time, John Tyner, and thank you.
Hi, I'm John Tyner. I have a presentation which is actually meant to be given to professional groups and law students. So I can take it down a notch. And I think I have to. Ron, is there any place to put my okay, and I provided you two documents. One, because these are actually in the news. These are my cases in the last year in the Oregon Supreme Court, and they're the newspaper article, which came over very poorly, talks about some of them. The cases have an interesting import. Involving right to counsel. And I'm going to have my brother Joseph send around some things too. So you've got a summary of my written remarks, and that's on the one-page double-sided form right there, and also the newspaper article. Can everybody read the newspaper article? It's terrible. Can you read it at least a little bit?
It's readable.
Okay, I'm going to have Joseph also bring around some show and tell. These are briefs. When a case, and stop me anytime, when a case goes to the appellate courts, we have color briefs so the Court of Appeals can see them. Al? Okay, Emily? So the blue form usually initiates it. The red is responsive pleading, and the yellow is a petition for review to the Supreme Court. So, as everyone's aware, probably, in our system we have a two-formed situation. We have a federal and a state system. And the federal constitution controls, but each individual state has a state constitution which can be interpreted. And at the trial level, just like the federal district court to the courts of appeals and the Supreme Court, in Oregon we have a corollary. We have the Oregon trial courts called the Circuit Court, and the Oregon Court of Appeals, and then the Oregon Supreme Court. Most cases in this country happen in state courts. Very few cases go to the federal courts, and the federal courts want it that way. In the federal system, you have courts of federal jurisdiction. For example, in a university where there's discrimination cases under Title IX, those would go to the first level to the federal court once the administrative hearings at the university are done. But a DUI case or something like that would go to state courts. So you have federal question jurisdiction and diversity jurisdiction federal court, and everything else is state court. I'm going to talk about state court cases that went to the Oregon Supreme Court. And this is going to take a little bit of getting used to, but like the Supreme Court, U.S. Supreme Court in 1979 explained and authorized what states have been doing for a long time. States were allowed to interpret their own state constitutions so long as they didn't conflict with the federal constitution. So the cases I'm citing here involve a right to counsel case, and that's Jesus Prieto Rubio, and a case that followed that, State versus Boyd, and that's Article 1, Section 11, the right to counsel. As you remember from civics, that's like the 6th Amendment on the federal level. The next one is State versus Gim, And on the state court level, that's Article 1, Section 9, and those are in your materials. And that's search and seizure, like the Fourth Amendment to the US Constitution. The next case is, you probably read about these cases. These are 3 strikes cases involving sex offenders. Sex offenders convicted of a 3rd strike in Oregon get life sentence. And that's would be under the 8th Amendment to the United States Constitution, but Article 1, Section 12 of the Oregon Constitution. Does everyone have their sheet of paper? Okay, I'm going really fast, and I know that it's going fast. In Article 1, Section 11, that's your right to counsel, like the 6th Amendment. When do you have a right to counsel when you're being questioned by the police? It was the issue in Prior Rubio. Mr. Rubio was convicted at the trial court level based upon statements he made to the officers after he had a lawyer, but the police wanted to question about some other instances, and they thought it'd be embarrassing and inconvenient to have a lawyer present while that happened. So they knew that I was there, but they didn't care. They interrogated him in the jail while he was in custody on matters which were related to the other prosecution. I objected to court, and I have some documents here. I filed a motion to suppress the statements. A judge heard those at the motion, denied the motion, so we went to trial with those statements in the case. And those statements were inculpatory. Basically, we then appealed to the Court of Appeals. And the Court of Appeals said the officer shouldn't have done that, because if you have a lawyer and the case that you're being questioned on is related to the other case, that lawyer ought to be informed. Believe it or not, that case that had not been settled yet in Oregon. The Court of Appeals ruled that the police shouldn't have done that and reversed his convictions. The state wanted a little more authority on that, so they went to the Oregon Supreme Court. And recently, the Oregon Supreme Court agreed, and they set up a test. And the test was essentially is how related was the matter, and should an officer have reasonably believed that the information he was divulging was so related to the other case that he should inform the attorney so the attorney could be present to protect their interest. So again, this was under the state constitutional provisions. That's Article 1, Section 11. I think I have a text of that in here. I don't expect everybody to read it with great detail, but that case set that out. There was also another case that followed that, because this had been a bit of a controversy. When you get to speak to a lawyer, is everybody with me here, or am I losing the audience?
No, you're okay.
Okay, there's a case called State versus Banks, like State versus Boyd, that followed that. And in State versus Boyd, the police questioned, got an incriminating response from the defendant after he invoked his right to counsel. The police arrested the defendant after his girlfriend was found dead. If you're doing criminal defense, there's always awkward things with your clients, like sex abuse and death, and you'll just have to take into account that the U.S. Supreme Court said that in Gideon versus Wainwright, that everybody's entitled to a lawyer, and the lawyers have a duty to zealously represent their clients. So, the Boyd is a murder case, and the girlfriend is dead. Just like in Prior Rubio, that is a sex abuse case. Basically, detectives questioned him, and he became agitated and was in disbelief that his girlfriend was dead. He goes, "Oh my gosh, she's dead. I don't know why I'm here, so why am I here?" Unfortunately, he subsequently made some statements which could lead the police to believe that he actually knew why she was dead and why he was there. But those that occurred after he asserted his right to counsel. Basically, with that information, a reasonable jury decided that he didn't know why he was there and didn't know why she was dead and convicted him. The issue is not whether he did it or not, it's whether the police, after he asked for the lawyer, were entitled to question him further. And like in this case, yes, sir.
In the middle of interrogation, if you make the statement, you have a right to counsel, does that stop the interrogation right then and there, or does it keep on going?
It should stop it right there under the Fifth Amendment. There is the Fifth Amendment to the U.S. Supreme Court says that when a person's in custody and being questioned about the police by the police about a substantive criminal matter, you have a right to counsel, and then what they call the Miranda rights are implicated. Basically, if the police then have to give the Miranda rights, they explain you have a right to counsel, etc., and you don't have to talk any further about the matter. So theoretically, an officer would want to be careful when he gets close. You say, all right, you're going to do your Miranda rights there. Most people, even when they're Mirandized, continue explaining everything for some interesting psychological reason. But sometimes the police don't want to interrupt the flow of the narrative of the interrogation by telling them about the Miranda rights, because they think that might inhibit a person from confessing. Fortunately for society, most people hear the Miranda rights and keep on confessing. So they get the convictions anyway. But sometimes somebody might say, well, you mean I can be convicted of this and I have a right to a lawyer and I don't have to keep talking? The officer says, well, yeah, okay, then I'm stopping talking. Now that happens so rarely that it's almost an anomaly in the law, but occasionally it does happen. But just in the chance that an anomaly like occurs, sometimes the officers don't tell them that. And that's of course called a violation of the Fifth Amendment rights. So to answer your question more specifically, a reasonable person, if told that the statement they're likely to make could involve their prosecution, that they don't have to make it, or at least don't have to make it without a lawyer, would stop. So the police know that. But sometimes when you're talking about death, sex abuse, and things like that, a person might want, a police officer or anybody might want to find more about that. And the artificial restrictions sometimes don't stop people. Okay, so the statements that he made about the baby girl, I gotta call my baby girl, came in and they were actually used to convict him because he showed some knowledge. The Supreme Court said, well, guess what? Under the Prieto-Rubio case, the officers knew that he was going to be incriminating himself, knew that it was obvious the tenants wanted to do this, and they should have gotten a lawyer there or stopped the interrogation. These questions were reasonably likely to elicit incriminating responses by either cornering defendant into a far-fetched theory of defense, which jurors would probably not believe, or provoking to make inconsistent statements to be used for impeachment. And because the interrogation led defendant to speak again, there was a causal connection between the unconstitutional act and the statements. So again, you have to have an unconstitutional act, which is asking the person past the point that they're supposed to, and then the person actually doing it. So again, we're not dealing with, this is not the Mensa Society, at the meeting of the next Mensa Society, and you'd be surprised, many of the people who are prosecuted or investigated for criminal acts don't qualify for Mensa membership. That's surprising, but the most interesting thing is Article 1, Section 9. That's the search and seizure provisions, and that's where most of the action in criminal law is, because there's a thing called the exclusionary rule. And for historical reasons, the federal and the state government have different rules for exclusion of evidence. Under the Fourth Amendment, there's what they call a reasonable expectation of privacy. And that came out of a case which would be quaint today, called U.S. versus Katz. Katz was on a taped telephone booth and was making statements. The issue was whether he had a reasonable expectation of privacy in that phone conversation. That's at least 50 years ago, back when the government wasn't routinely tapping people's phones, and back when you actually had telephone booths to talk in. So, and that's the interesting thing about U.S. versus Katz. As technology has improved, the parameters of our reasonable expectation of privacy have narrowed, and so the logical inconsistency in the federal rule is you have a reasonable expectation in privacy in certain things, but everyone knows that's just narrowing. And because of various technology and social norms, what actually a reasonable person would believe is a reasonable expectation of privacy is hard to figure out. We had the case here in Oregon where, believe it or not, they have devices sensitive enough to determine electrical usage and water usage in a house, and then you just drive by the house and scan the house they can actually tell who's on the toilet and which function you're actually performing. And that was a case called State versus Kylo. That technology is very useful for determining energy consumption. So if a person has, at that time, marijuana growing in Oregon was illegal, so you can tell by the thermal signature whether they were using excess power to grow marijuana. You could also tell the person in the upstairs bathroom was standing or sitting on the toilet. And the Supreme Court decided that was a little excessive. And so the results in the Kylo case were suppressed and were not able to be used by the state to prosecute the person for the violation. But it's kind of controversial. Oregon has its own, this is an interesting thing. Oregon has its own theory of under Article 1, Section 9. No law shall violate the right of people to be secure in their persons, homes, and papers against unreasonable search or seizure unless a warrant shall issue or upon probable cause or by oath, affirmation, and in particular describing the place to be searched and the people or thing to be seized. Oregon decided that there was a logical incongruity with allowing technical advances to determine the sphere of privacy. So what they did is they said, we're going to find out that there are certain privacy interests, and these are discrete privacy interests which exist outside of what our technology does, and we're going to protect these by using a civil concept, a restitutionary concept. If you take something from me, you have to give it back. So in other words, if you illegally seized something that was within the privacy interests of the individual from whom it was seized illegally, you have to give it back. In other words, that evidence can't be used against the individual. Unfortunately, that clear enunciation of the rule in 2005 has been somewhat eroded by the recent Oregon Supreme Court because they've incorporated certain principles of federal law. In federal law, the courts basically said if an officer reasonably believes and didn't do anything wrong, then basically the evidence may come in because it's a deterrent. The rationale for the Fourth Amendment is to deter illegal police conduct. In other words, they can't use the evidence because it makes them less likely to want to use it badly. However, in the federal system, in a case called Gates versus Illinois, if an officers reasonably believe that they're doing what's right, then basically there's no need to deter them from wrong because we're trying to do right anyway. It doesn't make any sense to me, but that's the current federal law standard. And we've incorporated that standard. That's probably a little bit too much editorializing. Let's just put it this way. If technology is narrowing the protections of the Fourth Amendment, and you create an exception for good faith-based belief, you further limit the Fourth Amendment. So a lot of states are kind of going to Oregon's, what was formerly Oregon's view, which is that you have a discrete area of interest, which is considered to be a privacy interest, and if that's invaded, the restitutionary thing is to bar the evidence, give you back what you had prior to the violation. However, recently the Supreme Court has decided that that was too clear, and so they've imposed, in a series of 3 cases decided September of a couple of years ago, that they were going to talk about things like whether the officer had a belief that was wrong, which was your right to be in the property, etc. So what was the right that's being protected? So I'm not really sure there's a good statement of what the statement of Oregon law is right now. But in 2005, at least, the then Supreme Court Justice said, we're an Article 1, Section 9, restitutionary privacy rights remedy state. And all that other stuff about Fourth Amendment stuff, that's great for the feds, but we don't have it here. We do have it here, and nobody really knows what search and seizure law means right now until the Supreme Court tells us. So, here's what they told us. I was representing a company, a mortgage company, that like a lot of other mortgage companies started cheating when things got tough, when the bottom fell out of the economy. And they started operating a Ponzi scheme. And they got caught. But the way they got caught was the securities division of the state of Oregon did an administrative subpoena for bank records. Unfortunately, they screwed it up. And they didn't subpoena them properly. But they conducted an administrative proceeding under the securities laws, and then turned the information over to the state of Oregon, which then prosecuted the folks. And a motion to suppress was filed on the basis that there was no right to those bank records because they weren't properly subpoenaed. And I saved this surprise for somewhere after the start of the trial. And the state requested a set over to deal with it. The Judge Knoxville granted that reset, and they went out and subpoenaed all the records again and brought them into court. And the records were very voluminous in this case. My clients were defrauding a large number of people who were involved in real estate transactions, all of whom were pretty unhappy about it, as you might imagine. So in any event, I wasn't saying that they get the good conduct pass. I'm just saying you're prosecuting, you got to do it right. So the judge allowed all the evidence in, all the records and that were seized in, and naturally they were convicted at the Court of Appeals. But the issue was this: do we have an Article 1, Section 9 privacy interest in bank records? Are bank records the type of thing which ought to be private? And a lot of people thought that they should be. In Washington, under Article 1, Section 7 of their Constitution, they are private. You have to get a warrant on probable cause to get that information. Okay, so the trial court allowed the information in, allowed it to be resubpoenaed, acknowledged that the administrative subpoena was invalid. Well, here's another little bit of law you have to know. Administrative agencies are creatures of the legislature or Congress, and their mandate extends only to that given to them by legislation. It's a delegation of power. So an administrative agency has a delegation of administrative power within its statutory authority. The statutory power authority of the Securities Division is to avoid people like my clients from ripping off the public. And they can subpoena information, they can make administrative decisions, they can have administrative sanctions. I think you saw this most recently with the lesbian cake. Basically, the Bureau of Labor and Industries regulates that particular area, and the fact finder was originally an administrative judge who heard information, and then the director of the department heard it and then was referred out. So if you're dealing with an administrative remedy, you deal with the administrative agency, then you can eventually go to the state court or federal court, depending upon whether state court authority or federal court. So remember, the Bureau Director, elected director of BOLI, Mr. Avakian, reviewed the case, and I think it was administered a fine. Administrative agencies don't have the authority to put someone in jail, but they can fine, suspend license, or do things within their purview. So the administrative hearings group, the administrative process here in the Securities Division was they administratively issued a warrant, improperly as it turns out, had a hearing, sanctioned, and then referred to the criminal places. In criminal court, you can fine or put people in jail. And so the state had used the administrative process until they found out that subpoenas had been improperly subpoenaed. Then they had to resubpoena it again. Is this getting a little too complex? Okay, so they resubpoenaed again, brought it to trial, convicted, and I filed the notice of appeal to the Supreme Court. And at this point in time, Morgan Daniel of the State Public Defenders took over the case, and the Court of Appeals ruled there was no Article 1, Section 9 right of privacy in bank records. The Supreme Court, however, took review of this, and one of the more interesting cases that's up there decided not to decide it. The convictions were out there, but they didn't like the way the case had been structured to be able to make their constitutional decision. So they overruled the Court of Appeals that there is no Article 1, Section 9 right of privacy in bank records, but they also ruled that they weren't going to suppress that evidence. And so what they did is it's called, in football it's called punting. But they sustained the conviction. So right now, with regard to bank records, we really don't know where we are with regard to Article 1, Section 9, rights of privacy. Yes?
I'm totally confused. It sounds like they said that, they talked about the right of privacy and then ignored what they just said.
Well,
But there's gotta be more to it that we're missing.
well, Justice Reeves Kistler and I litigated when he was in the Department of Justice. He's a former clerk to Supreme Court Justice Lewis Powell. And he's been on the Supreme Court now for a number of years after he left the Department of Justice. And he's a very smart guy. He's a lot smarter than I am. So I just assume the higher mind is more complete. So in point of fact, I don't understand either. But
do you think there's a level of information that we don't get?
Well, no, actually, I'd be facetious. What it means is what it means is that the Supreme Court didn't want to make a constitutional ruling on the quality of the record below. There's something called the fruit of the poisonous tree, and everybody who's seen Law and Order probably knows what that is. That's when evidence which is illegally served is seized, basically gives the fruit, which is the evidence to be sought. And the issue is, if it was illegally seized at first, then it's illegal to be used later. And the court didn't feel at the Supreme Court level that had been adequately vetted, that basically the full review had been given. They technically thought it was maybe a little unfair for me to spring a surprise in the middle of the party, in the middle of trial, and so they wanted that looked at a little bit. But they've established a template. The next time a person has this issue and wants to perfect it for Supreme Court review, they say these are the steps you have to go through. But they did not want to do what the Court of Appeals had done, is just say there is no constitutional right of privacy in bank records. So it's an open question. So this is out there to show the sort of indeterminate nature of some of these decisions and how flexible and sort of fleeting they are. If you asked me prior to, let's see, when it was, prior to October 13th of 2016, the controlling authority was the Court of Appeals, and I would have to say, if you ask me, there is no right of privacy in bank records. But the issue is on review to the Supreme Court, and we'll find out. And the Supreme Court basically overruled the Court of Appeals, so I can definitively say right now I have no idea what the law is. So the next time a case comes around, if a lawyer is diligent enough to actually review the Supreme Court cases prior to taking a case to trial, they'll at least have a template on how the Supreme Court thinks you ought to preserve those issues. So sort of like one of those things that laypeople folks just hate to hear. You mean, I paid you all that money, you can't tell me the answer? I said, well, actually, that is the answer. Very unsatisfying, I get that. Now, the interesting one is a defendant has a possessory interest in undelivered mail. A lot of people didn't realize the Post Office works with law enforcement, and basically certain parcels are separated out. I didn't know this either. At the post office for police review to determine whether it contains illegal things. The theory was a package had been sent, and the police took it for a dog sniff, moved it off the regular rolling thing in the post office for a dog sniff, and then consulted the person and said, would you consent to having this package searched? And since the police were there, they had the package. He thought, well, he thought resistance was futile, to quote the Borg term, and he consented. But the first issue is, does the addressee have a protected privacy interest in the package? Again, we're talking about Oregon Article 1, Section 9 jurisprudence. Do you have a protected interest in this piece of property? That's the first thing you have to say. Likely, if Al Young leaves his backpack with methamphetamine out in the parking lot, he's probably abandoned it. Whether in fact the officers can then search the closed containers in the packet is another thing. But if it announces its thing and says Al Young on the top and it's open and there's a substance which appears to be methamphetamine in it, we could decide that Al had actually abandoned the packet and he might not have a possessory interest in it. But in this situation, you had a package in the post office which was addressed to the sender, mailed to the sender, which was diverted from the regular commerce to have a dog sniff, which determined there was probably drugs in it. And the issue was, The guy consented, yeah, you can search the package. You know, is that no harm, no foul? Police thought so, but the Supreme Court had a different impression. Basically, they thought, well, if he has a possessory interest in the packet, what specific things about the packet announce, under Article 1, Section 9, that it's somehow particularly describing the object. What is there about this which is unique in such a way that you don't need a warrant, and you don't, basically is, why can't you just open it? The court said that that he had a constitutionally protected privacy interest, and that it was a possessory interest, and the package had his address, and which showed his possessory interest. And they're saying, the state said, well, he actually didn't have it then. It wasn't in his possession. But they ruled that not all constitutionally protected possessory interests in property are necessarily accompanied by possession, which means active possession, holding right here, or constructive possession. Constructive possession is a right to possess, or something could be legally inferred that you're possessing it. For example, if Al goes out there in the parking lot and says, oh, thanks for finding my backpack, who put that in there? You know, the police are there looking at it, and they say, well, it's your backpack, we believe it's yours. He said, well, are my fingerprints on it? No. He says, in the interim that I left it there, someone must have put that meth in my backpack. And so then you have an issue. What's constructive possession? What's actual possession? Was it added later? So these things aren't always as easy as it might seem. Now let's get to the one that's a little sexier. You have the article, which I apologize for you. I tried to get through my copy, but this is the so-called three-strike sex rule. And this is actually, would be an Eighth Amendment case in the U.S. Supreme Court, or an Article 1, Section 16, excessive bail, fines, and cruel and unusual punishment case in the state court. And nobody's going to like Mr. Davidson, Mr. Althouse, or my client, Mr. Sokel. Mr. Sokel is a graduate of Michigan State in biology who worked as a wildlife photographer and a park ranger, but unfortunately in the interim he also molested little girls. I don't think they taught him that at Michigan State, but in 1996 he was convicted of molesting a 12-year-old girl in the Kmart, and I represented him on that. And then some years later he was arrested in Newport for the same thing, and also at the Hillsborough Library. He pled out to an attempted sex abuse in Newport, but was convicted after trial in Hillsborough of the sexual touching at the Hillsborough Library. Judge Irwin listened to all the evidence and basically imposed, because it was the third conviction, the life sentence. He was, I think, 68 years old at the time. Two other cases came up there. One, Davidson. Mr. Davidson was 18 years old, got hit in the head with a baseball bat, and he had severe brain damage. And unfortunately, a lot of brain injuries manifest themselves in sexual acting out. So he's what you call a habitual masturbator. It's called, the first time you get convicted of it, it's a misdemeanor. Second time is a felony, and every time after that's a felony. So Mr. Davidson, on his fourth conviction, was sentenced by Judge Penn in Marion County to a life sentence. And Mr. Althouse was also a sex offender on his third strike, but he had a sex one and a sodomy, but his third strike was a public indecency, a public masturbation. So the issue was, what are the parameters of protection on these three strikes rule? And the court looked at these three cases, Althouse, Davidson, and Sokel, and decided that Mr. Davidson could do life on the installment plan. Every time he exposed himself, he could go to his 24 months. But they thought that the life sentence for indecent exposure was too serious. So he's 33 years old, and I think he's had 4 or 5 convictions. So they ruled that a life sentence for the third strike was unconstitutionally severe punishment. You know, he may do a life sentence, just continue to reoffend all the way through, but he's not going to do a life sentence per se. However, Mr. Sokel and Mr. Althouse, since their offenses involved children, were held to be duly appropriate for the life sentence. If you see the article there, it explains are people able to read that darkened article?
It's readable.
Yeah, that explains the conduct. The issue is the state of Oregon spent about $1.8 billion on a $17 billion total indebtedness since the beginning of the state on 30 and 40-year bonds to build 9,000 prison cells after ballot measure 11 was passed. And so the issue becomes who is entitled to spend time in those cells and how long. And these cases sort of deal with that, because the answer can't be everybody because there's not enough space, because I don't think Oregon's prepared to spend another $1.6 billion building another 9,000 beds. So the issue is who gets to go there and why. But that's the overview politically of the thing. Here they talked about why is it appropriate to sentence Mr. Davidson to life, and they couldn't come up with a good reason. And they actually looked at the categories of crimes for which a life sentence was appropriate and thinned those out in the statute. But they thought Mr. Sokel qualified, and they distinguished Mr. Althouse's third conviction, which was also an indecency, public indecency, by saying that it was directed towards women who were above the age of 18. So they made the distinction for a public offense indecency thing is basically if it affects a child, it's more, I guess you're more entitled to do the life sentence than not. I sort of don't get that either, but I do understand. I do understand that you have to have a distinction. So life sentence without possibility of parole was unconstitutional as to Davidson because it was too harsh, but not as to Althouse and Sokel. And the distinction apparently was the fact that it was a child. And basically the testimony in the in Sokel's case is the girl was tremendously affected by this. She felt ashamed. She had difficulty going back to school. They homeschooled her. She was afraid of libraries. And so given the vulnerable nature of girls to this, it was thought that older women would respond better than children. So you have to read the cases and you realize how difficult it is to set a line, so to speak, in the sand to establish what is and what is not unconstitutionally harsh punishment. But the courts have to do it. So again, today we talked about the right of counsel, and that implicates the Fifth Amendment Miranda rights, and what types of, when can officers question people in custody. And the court spoke first in Prieto Rubio this year and validated his conviction. Given the time frame, just so you know, the time frame, Mr. Rubio cut a deal with the state and pled to attempted rather than completed sex abuse, and he'll be, after 5 years and change in the institution, he'll be getting out. But since he's not a citizen, he's likely going to be deported. He ran a chain of Baja Fresh restaurants in the area and continued to deny his guilt, but he recently pled out, I guess, to get out. And so just because the case is reversed doesn't mean the defendant wins. It was remanded back to trial to retry it without that evidence. And evidently, he looked at that and decided that he didn't want to take the risk because the original offer on the case was 150 months. Judge Cole imposed 90, and he actually served the 60 or so before at the institution before the case went all the way through the Supreme Court. And the DA's office, not wanting to bring the girls who are now 14, 15, 16 years old back to re-traumatize them, did the attempt and figured that that's a fair means of justice. Because the girls, when they testified, were fairly young. And that, by the way, as a defense counsel, when you're cross-examining children, especially young girls on the stand, that's not a particularly comfortable thing to do either. And all the things you sometimes see in court about defense lawyers beating up on being embarrassing, things like that, that doesn't happen because the fact finder, the jury, if a grown man is beating up on a 11, 12-year-old girl, your client is not going to benefit from that much at all. So it's difficult for everybody. It's difficult for the girls, difficult for the prosecution, difficult for defense counsel in those types of cases. And this is how this one resolved eventually. The police, obviously, when they made the contacts at the jail, were not happy that they had a person who they believed might be a serial offender, at least among the degree of kinship of the three girls who were all related. Essentially, the degree of kinship would be roughly translated as to a nieces. So the officers were trying to push this to get resolution of this. I don't think they're to be too much faulted for going to an area of some legal ambiguity. And with regard to the search and seizure cases, a lot of times public, if Article 1, Section 9 were put to a vote, believe it or not, it would pass, because it did. Basically, when the ballot measure passed, ballot measure 40 passed, it was declared unconstitutional. That was the victims' rights package. All of the component parts on single subject group, all component parts were resubmitted to the people. And since I was one of the lawyers in the Supreme Court that argued against it, when it went back to the legislature to reconfirm the ballot titles and things like that, I was one of the folks delegated to define the ballot titles and compose the 8 or 9 ballot measures that went back. And basically the victims' rights thing survived in total, except the motion to abolish Article 1, Section 9 failed. So actually one of the few Fourth Amendment type exclusionary rule things actually passed the voters in Oregon some time ago. I don't think anybody remembers that, but Article 1, Section 9 has actually been approved. So I think I've covered the ground, which are the right to counsel, the Prior-Rubio and the Boyd cases, the GIM, the Administrative Bank Subpoenas case, and the proportionality under Article 1, Section 12, the equivalent to the 8th Amendment. So if anybody wants to question me about those, I'm willing to take questions. I recognize this is sort of a graduate level or law school level course that's kind of simplified, but I think, did everybody sort of get the concepts? Everybody feel comfortable with it?
It's a smart group, John.
It looks like a smart group. I saw Alan and I wasn't sure, but okay.
First of all, I don't know why John thinks it comes off as not understandable. It came off as though he had been preparing this all last week, even though we didn't know until this morning that we were going to be asking him. So once again, thank you, John. And for those of you with questions, please line up. And I believe we have someone at the mic now. Thank you.
Just for information, excuse me, I actually been preparing this for some time because it's part of the law curriculum that I've already submitted to actually have law students and possibly lawyers pay me to explain this to them. So I've been preparing it. The issue is taking it to a level where people who don't have a law degree could understand it. That's the only complexity.
So
yes.
we can all pass the bar now.
You can practice law if you want to.
So I have a law degree, I don't understand the case. But I do have a question, John.
The mic's not on. Hold it.
No, although I'm that disregard that noise.
Okay, Phil Nelson, a forum member and retired lawyer, and never have practiced criminal law except for my prosecution, so I'm completely as befuddled as anyone else in the room. But I wanted to ask you a question, if you wouldn't mind, about the recent Malheur refuge case. And the reason I'm asking is there's an awful lot of unhappiness about what happened with the defense verdict, and my understanding is that there might have been some prosecutorial overreach in terms of charging the defendants. But I wondered if you had any comments you'd be willing to offer us about that case, or some insights that would help us understand what occurred.
Well, to be responsive, I wasn't one of the attorneys on that case. I did sit next to Lisa Ludwig for 45 minutes in court the other day, and Lisa was representing some folks, I believe one of the Bundy brothers. But I just have the same thing everybody thinks. Basically, when you're looking at it, there were, I think, as many as 9 informers in the group who encouraged some of the conduct, and it was a conspiracy, and the conspiracy sounds easy to prosecute, and many times is, but you have to be conspiratorial about something. And I don't think the jury was sure what that thing that was. It was to deprive the folks of access, the federal employees at the reserve, of access to their jobs. But the alternative theory was that there wasn't a conspiracy to do that. What they wanted to do is they wanted to popularize their conservative views about who actually owns the land. I see Representative First is here, and I think her answer would be the Indians owned it first, but apparently the Bundys think that they owned it at some point in the transfer of title, and the federal government's is a spurious interest. But I think it was a degree of governmental involvement in the process that caused the jurors to wonder when the conspiracy was formed, how the conspiracy was formed, especially when you have as many as 8 or 9 informants, including a guy named John Kilman, who turned to be a deputy sheriff down on an Indian reservation in Arizona who's actually conducting the arms training. So it's that whole thing. The government wants to investigate and wants to look at things, but at what point in time does the government's activities trump the criminal conduct of the individuals? And I think at this point in time, the jury, the federal jury, listening to that stuff, thought that even though the law might have compelled them to reach a certain result, they intended to nullify that because of the government's conduct. And I think that mine is the orthodox view of what happened. Jim?
Jim Cake, floor member. I have two concerns. One was that if the scheduled city employee didn't show up, shouldn't there have been an assistant city employee or the supervisor of the city employee? I mean, Beaverton has lots of city employees. And secondly, you use these colored briefs about the state court cases, but I mean, you knew that there were 4 members in the audience who have been to state court and won state court cases and won court of appeals cases with the colored briefs. So the colored briefs isn't really a bluff for the reality. Thank you.
It was more show and tell. Basically, a lot of people don't know what a brief looks like, and the color coding is merely the internal rules of the Court of Appeals. So when they look at something, they can see really quickly what it is in the formats. If you look at the formats, they're very, very formalistic, so the judges who see hundreds of or thousands of these can immediately find the parts of the brief they wanted to and the issues and get to the point quickly. So the colors, the format, and all those things aid the judges in reaching conclusions more rapidly given the volume of work they have to do. Yes, Representative First.
John, thank you. Elizabeth Burris, board member. John, I really, really appreciate what you brought to us because it is difficult to find one's way. But many, many years ago in law school, I was told that there are 2 types of courts in the United States, federal and state. But in fact, I was too shy to ask questions then. In fact, in this state, there are 7 tribal courts with full faith and credit, and I think it's important for us to know that those tribes have the right to court. But your lecture was wonderful, and I appreciate it.
Thank you. Ms. Arnold?
Kate Arnold, board member. I was wondering, based on your experience over the years, when you're looking at how our courts function in the area that you work in, if there was one thing that you could change that you think would make it be more efficient, work better, do you have anything that you would like to see?
Well, I think the access to justice issue that a lot of people have been associated with is the thing, because do not fall off your chairs. Sometimes poor people don't get the same quality of counsel and representation that people who can afford money to pay for. All the cases I cited were all retained cases. You know, they weren't public defender cases, and sometimes the limits on expenditures for public defenders, and I was a public defender for 13 years on part-time public defender on a contract. So I did public defender work for about 12 to 13 out of the 34 years I've been a lawyer. So I guess the access to justice issues on the criminal level, and it's actually worse on the civil level because you can't formalize the issue and get it to a lawyer to have some legal form put to your grievance, it's really not heard. And a lot of things are where people have rights to do something, they can't actually effectuate those rights because they don't know how. And it could be access to public benefits, it could be objecting to an easement over your land from a government entity, it could be almost anything. It could be knowing that you have a right to contest a will. If basically your father marries a 21-year-old woman and he dies and all of a sudden there's a new will up there and you and the kids are gone, a lot of people from the will, from taking, you might have a right to claim there was undue influence, but if you don't know that you have the financial ability to execute that right, then you might not be able to follow up on it. And that's just an example. That's a kind of sexist example, I guess, but that's just an example that came to mind.
So is there anything we can do as in our society to make that more fair?
I think that's the issue. Gideon versus Wainwright, which was prosecuted by the Polk and Arnold firm, and I think former Supreme Court Justice, one who was actually removed, was the lead counsel on that. But you know, Gideon filed the trial court stuff himself, asking for the lawyer But it took the existence of a huge law firms with incredible resources to actually brief that and get that to the Supreme Court. So how do you provide a benefit to people that someone has to pay for in an equitable manner, I guess, is the issue. You have legal aid, you have various things of that nature, but how do you actually make sure that Donald Trump has the same legal existence as somebody charged in Portland who's very poor, and that's probably impossible. We ought to seek it, but it's aspirational more than obtainable.
John Blackman, forum member. Going back to the package in the post office, law enforcement has reason to believe, due to a dog sniff or other technical analysis, that there is drugs or money or something in there. Could they not, would it be legal for them to stand by and watch delivery and then immediately arrest the person for possession of this and that and the other thing?
You mean if they see it coming off the rack at the post office?
No, I mean at the point of delivery.
Right. I'm trying to think of how the hypothetical would work out. The person gets the package, walks out there and opens it up and exposes the cocaine to public view, then yes, it's now in what's called plain view.
No, I didn't mean that. I meant that they had, due to some, you said a dog sniff, would that be enough that they could immediately seize the package then and there in the post office? As soon when the person got possession of it, he now possesses it, bingo. Well, we have reason to believe that there is contraband in that.
They could go to a judge. They could go to the judge and say, Your Honor, this is addressed from the Cayman Islands. This is going to Mr. Simoli, who's Italian, who apparently hasn't ever been to the Cayman Islands before. We noticed some problems with this address in the past, has received packages of this type, and we have a dog sniff, which indicates that this is probably contraband. The judge would look at that and say, well, there's a specific offender facts and offense facts, legal ones, that they feel confident beyond more than 50% to issue a warrant for this. Now, dog sniffs are another area of ambiguity. Some dog sniffs are okay, some aren't. I won't want to go too deeply into it, but if a judge decides that this dog sniff is valid, that the location of the origination of the package is such that it gives some indication it might be illegal, it's traveling in a way which indicates that it might contain contraband. But under Oregon law right now, the officers can't themselves do it, and they can't enter the house where it might be open. They can't stop the car the person might be driving. You get an intervening order from a magistrate, a judge, to search that. Whether a judge would sign that affidavit or not, sign that order or not, based upon the officer's affidavit, is kind of questionable. But that would means by what you do it if you really want to get that evidence.
Thank you.
Okay, back to the question, as far as you were talking about the poor people not getting good representation. I've worked with refugees for many, many years, and Oregon's going to take a lot more of them. I have done a lot of paperwork for the courts, and I have no legal background. I've done very well with it. I have gotten people out of prison, et cetera, et cetera, et cetera. I'll tell you a situation of a family that the man, because he was a black African man, was arrested and not the mom. Incredible abuse of 2 children. No legal representation. I wasn't able to help. Everyone's asking me to get him out of prison. Him, I wasn't able to help. Years later, 3 children later, 5 kids, finally taken out of this, away from this woman and put in my house. This was many years later. Came full circle back around. But again, the representation. Oregon has decided that they're going to take a big number of refugees, and there are a lot of issues, and they don't have representation. What is going to happen with that?
Okay, if we want to get the mechanics of it, the bar has a process by which lawyers' trust accounts are debited the interest over and above the operation of the accounts, which is put into a account which is used to pay for indigent services for civil people, and lawyers contribute to a campaign for equal justice fund, which in some years exceeds $1 million or $2 million, which is then, along with the state disbursements, federal disbursements, allocated to legal aid services around the state. But given the volume of the demand that you're sort of not acknowledging and we all know exists, it's kind of a pittance. So the big problem is how you allocate the resources to the need. And a lot of lawyers are underemployed right now because of the excessive graduates that came out of law schools in the last 7 or 8 years. And law schools are all retrenching and getting smaller. It's possible that the people could decide to do essentially a legal, America Vista type program, and young lawyers who want to work off their debts could be credited that with toward debt and perhaps being housed someplace in a legal aid office and provide services while they learn the law to indigents. But there's another big problem is a lot of people in the middle, not just folks who don't have money, a lot of middle class people can't afford basic legal services like wills, estate plans, and things like that. So it's not just delivered to indigents, refugees, but I think it's across the board. A lot of women take divorce settlements which aren't appropriate because many times women have lower financial ability to contest some of the divorce decrees that were rendered. I think Emily can tell you that she's probably seen a lot of that. So it's problematic in a legal system where you don't get punched somebody in the nose because you disagree with them. You go to court. If you can't get to court, you essentially can't defend your legal interests.
We're done.
Oh, we're 5 minutes.
You want to do it? Go ahead.
Thanks. John, thanks. Spencer Irwin, floor member. I was troubled by something you said early on that was not necessarily related. It had to do with the banking scenario that you painted up, and has to do with a regulatory agency of the state sharing information with the Department of Justice. In other words, let's say Department of Environmental Quality, which licenses industrial concerns, and they're allowed to emit certain substances into the air. If they discover that that the industrial company is in violation of their permit, they can take care of that and fine them and do things. But if then the Department of Justice piles on with a criminal complaint, the Department of Justice hasn't done any investigation. They're relying on another state agency to have done that investigation for them. What I'm hearing you say is that the court will allow that to proceed. Shouldn't there be some presumption on the part of a law enforcement agency, the police or the Department of Justice, that a crime has been committed before then they have to go out and do the investigation? Am I making my question?
Yeah, you're wondering why under the delegation of powers, when the Constitution says that the executive is charged with the prosecutorial function, why do we subdelegate it down to administrative agencies to do that? And how can administrative agencies then, within their delegation of authority, then turn it over to the constitutionally delegated person to prosecute criminally? I guess, given that the folks who were originally supposed to do it haven't done it yet.
Right.
Yeah, well, the answer is, we don't know. Basically, the classic case is, Answer Haggerty in federal court was dealing with a securities issue. And the issue was whether the SEC, on the civil side, could turn over the results of the consent agreements with the parties to the Department of Justice for prosecution. What had happened in the case was the SEC just, the Department of Justice just waited out here until the SEC got all the information, and they settled the civil case and turned on and prosecuted them criminally. A lot of people are troubled by that, and I don't think that's entirely clear. Justice Haggerty at least ruled that it was an abuse of power, but I think the Ninth Circuit overruled them. So the issue of what types of things get to be offered an administrative body is something that's still developing. For example, the Department of Motor Vehicles administers license suspensions for DUI violations. The same evidence is then used in the criminal case, and the same officer that testifies at the DMV suspension hearing also will testify in the criminal court. And the testimony of the driver, called the petitioner, if they testify the case, will be used against them in the criminal case. So in other words, a person testifies to keep their license, and then that's used against them in the criminal case because they waived their rights. So we allow that because we believe that this quick and summary administrative process has benefits. In other words, suspending DUI driver's license kind of summarily And we also believe that people who drive illegally ought to be incarcerated and penalized in some way. And so when those things work together, a lot of people wonder how that's done without negatively affecting people's rights. And I guess what the Supreme Court says is that your right to a license is somewhat less important. It's actually a privilege. Therefore, the Fourth Amendment can be conditionally used in that situation, but you don't have a privilege to drive. It's not a constitutional right to drive. So you could, if you don't want to offer evidence against yourself, just don't do the hearing. Let them suspend your license. Okay, that's all I have. Thank you.
Thank you, John, not only for a really great presentation on the spur of the moment, despite all the work that went into preparing it, but also to be able to answer some broad, wide-ranging questions, and from an audience that Emily did already declare to us is pretty darned intelligent, and the audience just spent the afternoon proving it. Ladies and gentlemen, next week, boy, am I really looking forward to next week. Regardless of what happens tomorrow, we'll hopefully have some better understanding of it a week from today, as we're fortunate enough to have Professor Moore from Pacific University, who will be discussing the results of tomorrow's election. Sorry, typical other things came to mind, but we'll call it tomorrow's election. Thank you so much for being here, and one more time, really, applause for John for stepping in at the last minute.